Good evening, everyone. Thanks for joining our monthly Labourlaw update for the month of June 2022. There not been any kind of amendment or ordinance to any labor law this month. So we are afraid there's nothing for us to share there for you. But circulars, the Tamil Nadu government has allowed all shops and establishments to be open 24/7. So you could be open across the night. It's like a factory that can work in 3 shifts. Your shops can also now be run across, or a restaurant or anything could be open all through the night. However, they have laid down certain conditions for that, and especially with regard to employees. If you're to employ them after 8 p.m. or before 6 a.m. on any day, then there are various other conditions that are imposed more to do with their safety and workplace environment, and which includes providing transportation, etc., to the women employees. So this is a development in the government, in Tamil Nadu. The Haryana government had also allowed women employment, that is beyond 7 p.m. and before 6 a.m. on any day in various sectors. What they have now done is, however, they have revoked the exemption, which was a blanket exemption. Now they want the employers to apply for the exemption, and they give the exemption on a yearly basis. So normally the trend has been to do away with paperwork, but here they've brought in more paperwork, and they want to know who's seeking exemption and who wants to employ women workforce in the night shifts. So they have asked employers to henceforth register and seek an exemption. Provident fund interest rate has been announced for the year 21-22 at 8.10%. ESA has extended to parts of a district in Assam, has been extended the benefits. Moving to our next segment, the quiz segment. OSH code, what's the maximum was overtime in a quarter? 75 hours, 90 hours, 105 hours, or 125? Please do put in your answers in the chat box. Moving to the across the globe segment, where we look at new or interesting labor laws across the globe. In Poland, an amendment has been brought in recognizing work from home, remote working, but they also said where the work is hazardous in nature with exposure to chemical, physical or biological factors, or heavy soiling work, those kind of works can't be done from a remote location, but it would need to be only from the workplace. And the protection of in private rights of an individual, or personal rights of an individual vis-a-vis the workplace. They are now allowed breath analyzer and drug test to be taken in workplace. Dutch lawmakers want work from home to become legally, give it a legal background to it. So that way, anybody as a matter of right would be able to say, I want to work from home. That's what the Dutch parliament is looking at. It's not a law yet, but it's thought process that they're going through at the moment. In our knowledge corner this month, we are looking at abandonment of employment and loss of lien. What normally is thought is that if an employee were to not report for work and for a sufficient period of time, it could be assumed that he has abandoned his employment with an employer, or he's renounced his employment, is what would be the normal understanding that we have all been having. There are many case laws in that aspect, because many employers tend to think, oh, the employee has not come for 3 months, I will take it that he's left my services, and they just close the accounts and do all kinds of formalities with no formal communication in this regard. To point out that he has been absent or whatever, and then an employee could come much later, 6 months, 7 months, or even a year or so later. And when the employer says, oh, I already terminated you, and or taken it that you have abandoned my service, he goes to the court and they tend to succeed. So these are various principles that are there that you need to comply with. Courts want you to send communications to the employees to point out that they're not there, conduct some kind of an investigation before you uh, terminate the services or remove their names off your rolls. Um, this is a case where initial cases where a person went on strike and it was considered as an abandonment. Court said no, they've just gone on a strike. The question of saying that to be an abandonment would not arise. Similar cases are all that's been the trend. Of course, there was also one more in between trend of standing orders providing for 8 days, and once somebody doesn't turn up for work for 8 days, they deem to have not come for work. There have been conflicting judgments, but the uptake of what I would suggest is whenever an employee doesn't come to work, kindly ensure that some kind of a communication goes to the employee pointing out that it is he who has not come to work. Even if you don't hold a domestic inquiry, send 1 or 2 kind of show cause notices, and thereafter you may consider him as having left your services. In our Know Your Codes corner this month, under the IR code, standing order violation attracts 1 lakh to 2 lakh of fine, substantial increase in what was here as a consequence. The amounts have been increased, and this becomes 2 to 4 lakhs if it is going to be repeated. So the same offense or same nature of offense, if it's to be a subsequent offense, the fines could go up to 4 lakhs. And we are looking at just contravention of standing orders alone, and that's the punishment that the new codes are looking at. The Code on Social Security, and if you look at the Workmen's Compensation Act, which is now called the Employees Compensation Act, if you fail to pay, you pay a 12% flat interest rate. But under the Code on Social Security, compensation is not paid. The central government can prescribe the rate of interest. So it could be more than even 12%. In order to bring about employability skills of women, there have been a lot of partnerships that have been going to enable them to give access to it. So LinkedIn has also joined a UN platform where they for gender equality and ensure that more women are able to come to the workforce. And the skilled workers are being promoted to come to Australia. This is the case in the case law corner looking at this is a Supreme Court case law, once again reiterating that for purposes of Gratuity Act, only basic and DA needs to be reckoned, no other relevance. This is a case where some interim ad hoc payments are being made to the workers at the time of cessation of employment. Whether that ad hoc payment would also amount to a basic wage was a question. And the Supreme Court has held no, it will not. The ad hoc wages will not answer to the definition of wages for the purposes of Gratuity Act, and therefore have held it sufficient if basic and DA alone is reckoned. The petitioner in this case, the workman, he was proceeded with for not obeying orders of transfer and doing dharna, and he was then terminated from service. Union raised a dispute, and when the union raised the dispute, the petitioner was the general secretary of the union, but thereafter he was thrown out of the union. He was no longer a general secretary of the union, and when the case came to the labor court, the union was not prosecuting the case. So he wanted to come in and prosecute instead of the union, and the labor court said, no, you cannot do that. It's only the union which can prosecute. A single judge of the Madras High Court has held, given that he has to have a fair chance to defend himself and get his termination set aside, he could directly prosecute himself, and he doesn't need to depend on the union for it. Well, this case law, this judgment rather, I would say, goes in contravention of what has been held, contradiction to what has been held by the Supreme Court in the earlier cases, where they say it's a prerogative of the union and the individual employee doesn't have a say. But this judgment takes a departure on that and says that when the union is refusing to expose the cause of the workman himself could step in and he could prosecute his own dispute. In our POSH segment, which we have introduced recently as part of our Lex POSH, there's a very interesting case where an officer of the bank sends through SMS or through messages certain obscene and overt messages to a co-employee who was working in the same branch as him, but then she had moved to a different branch in a different state. So the officer took a stand that the person who was charge sheeted doesn't have, because she belonged different state and the disciplinary authority there alone could have issued him a charge sheet. The Supreme Court has taken note of the development in technology and has come to the conclusion that in a digital world, workplace could vary, and it doesn't mean that because the person who was harassed, that is the complainant, she was in a different state, will not mean that the disciplinary authority of the state in which the respondent was working will not have jurisdiction. And this will have repercussions when you look at various work from home situations. In the pandemic situation where we are, online sexual harassment, where can the complaint be given? Supreme Court has said that you can give the complaint in both places and both would have the jurisdiction. So the place where the harassed resides or harasser resides, and based on which the work culture comes in, workplace comes in, could be taken. Our reply to the quiz, 125 hours. I find many of you have replied to the chat with the correct answer. Our complaints chart for the coming June 2022 is provided for various. We will share the chart through the PPT presentation for those who have enrolled today. Thank you for joining. Hoping to see you again on 30th July at 4 p.m. Thank you.